Sam Seder on the Majority Report. Emma Vigeland out today. Joining us now, Chris Geidner, proprietor of the Law Dork newsletter on Substack. Chris, welcome back to the program.
Hey, Sam.
So it is, there's so much going on. And there are my understanding is there's something like 80 active cases now that are not all focused on what, DOGE is doing, but but certainly focused on DOGE and the slew of executive orders that Trump has issued. And we should say that a lot of times these executive orders aren't really anything other than sort of like letters of intent.
There's
go ahead, explain that to us.
Yeah, there's sort of three types of executive orders. There's like actual executive orders that, like, if you would read about it in a book, what you would be talking about, that it's directing something, it's something that is within the president's authority and he's doing it. And then there's other executive orders that in the past probably would have just been labeled like presidential memoranda that says, like, I'm directing the Secretary of Education to look into X. And then there's a third one, which is, I think, what you were getting about, which is more like, it's just sort of like Donald Trump's thoughts, or more likely Stephen Miller's thoughts, something like that.
But even in that third instance, it's, if I was to sit here and go like, man, I like being in a room full of fans. When, like I like the air circulating, somebody working here might go, oh, well, I'm going to turn on a fan because I know Sam likes it. I mean, some of the agencies do that, right?
Oh, no, the problem, and this is what we've seen in a lot of litigation, is like in some instances, what they're doing is so slipshod that it both makes a lawsuit easier and makes proving the things that you normally need to do in a lawsuit more difficult.
Because it's so vague. It's it's like you're arguing with air in some level. And I should also add,
sometimes that's ultimately good, as we saw like last Friday in the challenge to his anti-diversity, anti-DEI order, when the Judge Abelson enjoined provisions of those executive orders, a Maryland federal judge. One of the bases that he used for enjoining it was the fact that it's unconstitutionally vague, that it in effect was not telling all of these employers, nonprofits, outside companies, what it was that the order was even telling them they needed to do in order to comply with it.
All right. And let me just also say, just for clarity's sake, there's never been an instance where I have suggested that there's something I like in the office and anybody reacted to it. I just want to make that clear. Okay. So broadly speaking, we have 80 cases or so that are ongoing. Who are the plaintiffs here? Like in broad categories, and how much is that, are we seeing for the first time, like sort of like planning that has been going on the legal front? We're not talking about like the political front, because I'm quite convinced that there wasn't a lot of planning going on the political front. But on the legal front, it really feels like the people for 3 or 4 months, groups, maybe longer than that, had been sort of like gearing up. This is how we're going to deploy in these instances. Give me a sense of who the broad categories of these people are and how much of that planning has actually been going on.
Yeah. So, there's two, not to fight the premise of your question, but like in addition to plaintiffs, it's really important to look at the legal groups behind them. In some cases, it's more important who the lawyers are at the bottom of the filing than who the plaintiffs are at the top, in terms of understanding where it came from. Now, I think you're right in terms of like groups
go out and find plaintiffs to carry this out. And
so, what we have, I mean, they're really right now in this first little more than a month that felt like a year of Trump 2.0. What we have is sort of four main areas of litigation. We have funding litigation, that are these various funding freezes. We have removal litigation. We have constitutional litigation. And then we have sort of the grab bag of other lawsuits, primarily against DOGE, that have existed. And so what you have within that is different groups of plaintiffs. Most effective, I mean, obviously in the removal cases, the plaintiffs are the people who were removed. We have the one case that went up on the shadow docket briefly to the Supreme Court was the Hampton Dellinger, who is the U.S. Office of Special Counsel, not to be confused with Special Counsel Jack Smith and the other ones. But
this is not the DOJ one. This is like to protect whistleblowers in the U.S. government.
The whistleblower agency. Yeah, this is, I mean, sort of the ideal agency that Donald Trump would not like. So it's not surprising he is trying to fire the guy in charge of that. Within the removal, so that's limited who the plaintiffs are going to be. They're going to be the removed
head of one of the EEOC commissioners, one of the National Labor Relations Board commissioners. I mean, right.
There have also been like just more random employees who have been suing, saying that they've been improperly fired. Now, but those are all going to be plaintiffs.
Now, yes. Now, but the lawyers representing them and the groups that I mean, and I guess that's what I was, getting at. The groups behind it, have there been guys, people, broadly speaking, groups that have been gearing up? Like, he's going to come in. We know what Project 2025 is about. We know what Schedule F is. We don't know exactly who the plaintiffs are going to be, but we know the nature of the arguments we're going to be making, and we know which jurisdiction we want to bring this in. And that's what I want to get to in a moment. But give me a sense of those groups.
True. Citizens for Responsibility and Ethics in Washington, national security counselors have been sort of focused on some of the I mean, it's in the name, some of the more national security related issues with both on the firing front and the DOGE front. There have also been just more experienced employment lawyers. I mean, obviously the federal government employment is a huge area of law, and so they're doing that. Then we've got the funding cases, and Democracy Forward has been very prominent in those cases. There have also been
who's Democracy Forward?
Democracy Forward is sort of out of Trump 1.0 organization that Sky Perryman is running, and they've brought I believe like nearly 24 cases already.
Were they gearing up for this? Like,
they were ready on day one to be paying attention to some of, I mean, keep in mind, you've got like the things that Trump did in his first term. You knew he was going to be trying some of them again. You had the very prominent things that he kept talking about on the campaign trail.
Right.
And then you had Project 2025. And so you did have sort of three broad areas of plans that you could be looking at to be preparing. And sort of as he did these different things, some of these cases were filed, and you've gotten some injunctions already. You've gotten TROs. Some of the actions when either DOGE went into an agency or a new acting director was put in that was affiliated with or seen as very sympathetic to DOGE. One of the key areas has been CFPB.
Yep.
When they sort of took over CFPB, that's obviously been something that Republicans writ large and the Trump administration have been trying to dismantle in various ways over since it was put into effect. And the Democracy Forward brought litigation that's ongoing. I believe there was a hearing today in Maryland over their preliminary injunction request in that case. But, and this I think is really important, is that because of all of the litigation, something that we are seeing is that DOJ and agencies are in some cases willing to reach temporary agreements that they say, like, we won't take action while this case is pending, because they're just literally
stretched out too thin.
They're stretched too thin. And
I mean, that's what I have to say. Like, I've been very impressed about is that you're watching the response from the legal sort of, broadly speaking, the legal response has been so comprehensive in many ways that it feels like it's overwhelming. From our perspective, and in a political sense, and certainly in a news sense, it feels like the administration is overwhelming us. Like, they're flooding the zone. But from a legal sense, it feels like the plaintiff class, broadly speaking, and all the sort of groups that are bringing it back, have met that flood, have pushed back, and we're ready for it in such a way that now the flooding, to the extent that it's happening, at least in the legal front, is going the other direction. Like DOJ, because these guys are not. The one thing I will say about it is, like, they're going in to wreck government, and you don't need a lot of expertise to do that until you have to justify it in a court of law. And then all of a sudden you need to know what you're doing. And there's just not that many of them.
Yeah, you need very specific expertise, because you're going to be, especially, I mean, like, we are seeing in some senses sort of I would argue, a slightly more lawful reversal of what we saw in the Biden administration. Like, everybody's not just going to 2 judges in single district divisions like we saw, but we are seeing, like, everybody's learning about new courthouses. Everybody's learning about the District of Massachusetts. Everybody's learning about the District of Maryland. And because those go to the First Circuit on appeal, they go to the Fourth Circuit on appeal. So it's...
All right, let me slow you down here, because this was my next question, and I'm not sure people fully understand this. So during the Biden administration, what conservatives were doing to stop Biden policies, they were going to the Fifth Circuit, which is Texas, Louisiana, and maybe Oklahoma, is it? And Mississippi. Because the judges there, because of the nature of the way that federal judges get nominated, all very Trumpy, very conservative. And there were specific districts within those, within that circuit, where there's only 2 or 3 judges, and one of them is that guy Kaczynski or whatever.
Kaczmarek.
I want to say Ted Kaczynski, but pretty close. But they kept going to him, and he had the ability to basically freeze across the country, Mr. Priven, whatever it was.
There are 2. So in like districts, the Northern District of Texas, which has something like 20 judges, there are divisions, and there are 2 divisions that if you file a case in that division, it has a 100% chance of being assigned in the one single judge division to Matt Kaczmarek, and in the other one to Reed O'Connor.
So this is known as
using that
venue shopping, and the federal judiciary attempted to reform the rules on venue shopping, and they got so much pushback. I guess from, I don't know who,
from the Northern District of Texas,
from the Northern District of Texas.
and McConnell and Trump. But
so they stopped doing that. And now it's flipped. Now the plaintiffs, the people who are being represented, the judges, the lawyers, they're going and they're doing their own venue shopping in Massachusetts. And how are they deciding that?
They're doing it in a way that we've always seen. Like they're not going to a single judge. They're just saying, like, the District of Maryland will take us to the Fourth Circuit. And the Fourth Circuit is lopsided Democratic appointees, and we want to bring our appeals there. The First Circuit, that's New England, that has currently all Democratic appointees. And so when they bring it to the District of Massachusetts, they might get a Republican appointee, but they know that on appeal, it will go to the First Circuit where they think that they'll have a better shot. And so
where is our Kaczmarek?
In some ways, I would argue we don't have a Kaczmarek because our judges follow the law. Like we have them. Our version of a Kaczmarek or Reed O'Connor is a really smart judge who we think we're right on the law and we think we're going to get a really good ruling. I think a good example is some of the cases that we've had this week. Judge Amir Ali was one of the last judges confirmed in the Biden administration. He's sitting in the DC District Court. He had run the MacArthur Justice Center before he was a federal judge. He's very smart. He's was a progressive advocate lawyer, and he's now a lifetime tenure judge on the DC District Court. And so, I think that liberals were happy when the USAID State Department funding case got to him. But his rulings have been detailed, have been smart, have been designed to be able to be upheld on appeal, which I think is the difference between sometimes I think Matt Kaczmarek is issuing a decision knowing that even the Fifth Circuit, as conservative as it is going to overturn some of it, and he's just trying to get 50% of it through.
And giving somebody an opportunity to audition for the Supreme Court for Donald Trump. Let me just go back to one thing here as you talk about this, because maybe this is now, 15, 20 years ago, but Harry Reid sort of nuked the filibuster when it came time to fill the DC Circuit Court. And, we've heard people say in the past, he should have never done that. That's why the Republicans were able to, get rid of the filibuster for the Supreme Court. I'm quite convinced they would have done that anyways. We watched Mitch McConnell refuse to even have a hearing 9 months out for Merrick Garland. Not necessarily my favorite pick in that instance anyways, but then basically bring a judge in within 3 weeks before an election in another instance. But that DC Circuit still remains I think with maybe a 6-judge majority in the full en banc Democratic appointed. It could be more than that. I can't remember off the top of my head. But in moments like this, that is huge, isn't it? Because many of those cases, and that happened 15, 20 years ago.
Yeah, I think it is impossible to understate the importance of the judges that Biden was able to get through. The reality is that if we still had a filibuster, yes, some of the Trump appointees wouldn't have gotten through. But I think you're right that Mitch McConnell, as soon as he needed to, would have gotten rid of it at any level. I think that the end result is that we were able to get really excellent judges through who would not have been able to get through in a past era. I think the importance of professional diversity. Biden was the first president who really focused on getting
defense attorneys, civil rights attorneys,
ideal civil rights lawyer. Like in the past, there used to be like you'd have one or two appeals court judges who were public defenders, like whereas like Biden had dozens.
Yep.
And I think we will see that. Honestly, I think will be one of the longest lasting legacies of the Biden administration is how differently in a decade the courts are going to be looking at these issues, because we just have judges who actually fought the government. And that like was just not the case, because even Democrats were appointing former prosecutors
and just all corporate attorneys. You know, I mean that, and we should also say the level of aggressiveness that the Biden administration did in filling these judges means there's a lot less for Trump to low hanging fruit for him to fill.
Unlike the
Obama administration. Yes,
which I mean that was not all their fault. The Republicans had the majority in the Senate, but the fact is,
it was mostly his fault. It was mostly his fault.
Yeah, I mean, but at the end of the day, like you ended up with very, very few appeals court vacancies. I think there were like maybe 2 or 3, which is just an incredible job. Like it was so important, because I mean, I'm knocking on wood because it'll probably change the second after I say this, but like we are yet to see any Trump nominees for courts. And part of that, I think, to go back to our larger discussion, is because they've been too busy putting out these amorphous executive orders and then needing to go to court and defend them. And the one group we didn't get into, and I know we're running out of time, I just want to make sure I don't leave them out, is that the civil rights groups have been bringing those constitutional challenges. We didn't get into that, but like NAACP Legal Defense Fund, Lambda Legal, ACLU, like when it comes to the constitutional challenges, National Center for Lesbian Rights, these anti-trans orders, the anti-DEI, diversity, resegregation orders, those traditional civil rights organizations are on it and are bringing their lawsuits as well, and they've succeeded in getting either temporary restraining orders, preliminary injunctions, or the other thing we talked about, where like they'll just DOJ will talk with their client and get them to agree to take no action while litigation is ongoing.
And just yesterday, I think it was yesterday, or maybe it was the day before. No, this was Tuesday. Just yesterday. Like you mentioned, you had Lauren Ali Khan, preliminary injunction that blocks the administration from freezing federal grants and loans. That was an expansion of an earlier block. Before that, Amir Ali, who you mentioned, ordered the Trump administration to pay foreign aid-related money to government contractors and nonprofit groups by Wednesday night. That's amid the legal fight over freezing of U.S. aid and State Department funds. In that instance, Greg Sargent had a very sort of like just a disturbing story in, I think it was the New Republic, and I'll mention it later in the program, but broadly speaking, there are 2 companies in this country that create basically an emergency type of food for children who are literally wasting away. These are this is for foreign aid. Children who are so malnourished that they cannot eat regular food because they don't have the capacity to digest it. And it is this like, it's like pre-digested, almost like baby food, but high in protein, made from American-made peanuts, American, all this, American manufactured. The packages say brought to you by the American public. There's only 2 companies that do it. They're sitting on enough food to feed like 400,000 children like this, but they don't know who to talk to at USAID. There's nobody to like fulfill the contracts. There's nowhere to go. Does this order like release that money? Do you know? Or and just to add the third one, in Washington State, a federal judge issued an order about halting the suspension of refugee admissions and funding. Do we know, like, are they listening to the courts?
Yeah, I mean, this is a difficult, nuanced area, and there's sort of 3 answers. The first is, in some cases they are. In some instances, the order is unambiguous. The agency is able to do it. DOJ tells them, and they do it. In some instances, the order, I mean, you understand, like, I mean, if you put 2 lawyers in a room and show them a contract and tell them to fight about it, they'll find a way to fight about it. And so you have a little bit of that with these TROs and injunctions that, like, it's not surprising that the agency and DOJ are trying to interpret it as narrowly as possible. But then you do have some
now when they do that, when it's narrowly as possible, and I certainly understand the dynamic with lawyers having been raised by one.
Sorry.
Do the plaintiff attorneys at that time, they go, okay, you guys aren't doing this, we're going back to the court?
Yeah, and that is what has happened in the USAID case. There are 2 things that can happen. Either the plaintiffs decide that it's not happening, that they feel like it's not being followed, and they go to court, file a motion to enforce the TRO or injunction. Or what has happened, and I think is a good sign, that it's both a sign of sort of aggressive pushback from DOJ, but it's also a sign that it is an acknowledgement of the authority of the court. What they'll do is they'll file a notice of compliance that is, that they'll have language that's like, here is how we interpret your order. Tell us if we're wrong. And right. It might be an aggressive, like, you and I might look at it and say, like, that's ridiculous. There's no way that the judge's order excluded that. But they're doing it. They're going to court. They're basically putting themselves.
They're de facto conceding that there is authority over them that they feel like they have to justify to.
Exactly. And that's where we're at with Ali right now and this USAID funding, that, like, his initial TRO was February 13th. He issued an order to enforce it that was more generic on February 20th. And then yesterday he issued the order saying, okay, yes, as to the first order, the second order, and now I'm setting a deadline of 11:59 on the 26th.
Okay, so he's now, okay, let me ask you this, and TRO, just for people, temporary restraining order. And so he's doing, it's like I'm saying, like, hey, to my kid, like, hey, you're done with your iPad right now. You've watched enough screen time. I come back in 2 minutes later, and you're still on it. What are you doing? Put the iPad down. And I come back 2 minutes later, and I go, okay, you got to count to 10. And if you don't, you lose it for the whole week. That's where we are in that. But is there a way for plaintiffs to go in and go, like, hey, instead of let's telling the kid 3 times, how about let's start with, you got 3 seconds to put that iPad down, and otherwise we're going to, because
here's the problem, you might lose.
All right. So that's what I was trying to get to.
I mean,
strategically, is there a fear that if we push too hard, we're going to create a precedent where all of a sudden the administration feels like it's off to the races. Now we don't have to listen to anything.
Some of the standards for this preliminary relief, these are technically all emergency relief. And in order to do that, in addition to needing to show that you are likely to succeed in your case, you also need to be able to show what's called irreparable harm. And that's where you get into this issue. And that's where, when you've seen some losses, particularly relating to DOGE aspects, is that the judges are saying you haven't shown irreparable harm. And for some of these funding issues, for some of these removal issues, trying to get a judge to put a direct time limit of like 2 days from now, 24 hours from now, 48 hours from now, what the judge might say is, you can't prove irreparable harm in that time, so I'm denying it. You might be able to prove irreparable harm if
indefinitely
USAID just doesn't fund it, but you can't prove irreparable harm by Wednesday.
If it's not done by within a week. I see. So they don't get that aggressive, because if they make it that narrowly tailored, they have a better chance of losing the temporary restraining order or whatever it is they're looking for.
I think what we're seeing is in some ways better, because not only is it's the judge getting mad and not the plaintiff getting mad, but it is also setting up, and this is part of the reasoning. Judges, district court judges generally, Kaczmarek notwithstanding, don't want to be reversed on appeal. And part of this is judges being careful to make sure that they are establishing a crystal clear, solid record before they take extreme actions. Like if we do ever get to a point of a federal judge trying to hold a federal executive branch official in contempt, you want to make sure that the judge is able, and the plaintiffs on appeal are able to point to, there is no question that this was intentional non-adherence of a judge's order. We've got 3 weeks of briefing before this judge issued a contempt order. And I think that's what we're seeing is methodical steps being taken to ensure that compliance is clear on the legal front and on the timing front.
All right. So lastly, are you surprised at all by the administration's responses across the board? Like, in other words, their willingness, the compliance thing, the willingness to sort of like not contest. It does not feel, outside of like Musk and Vance at one point, I don't know when this was, like 2 weeks ago maybe, when Vance was like, these judges have no business doing this. Outside of that one moment, did you anticipate a more sort of like legalistic attempt or arguments to be deployed that like, no, this is like, it doesn't feel like there's an attempt to, whereas 2 or 3 weeks ago, it felt like there was going to be an attempt to bring an Impoundment Control Act case to the Supreme Court. It doesn't feel like that anymore. What's your sense?
I think there's two things. I think like on the end front, they still have faith that they've got the Supreme Court in their pocket. And so when it comes to Trump or Musk lashing out, I bet that there are people behind them behind closed doors being like, if nothing else, calming them down, preventing them from lashing out publicly by saying like, don't worry, these are district court judges. We've at the end of the day, we're going to win. So I do think if we get to the point when like the Supreme Court pushes them down, we're going to have a more make or break moment. The other side of it is that by and large, and this is when we were talking about sort of the steps that Judge Ali is taking, the district court judges have been very careful. They haven't been doing what Kaczmarek does and issuing these overbroad injunctions. When you look at like the order about the DEI funding last Friday, like the judge did such a good job of laying out, I am only going at these 3 provisions in these 2 executive orders. This is all that I'm doing. Here's my legal reasoning under vagueness. Here's my legal reasoning under the First Amendment. And that's why I'm doing that for these 3 discrete provisions of these 2 orders. And what that does is it makes it really hard for Musk, Vance, Trump, Josh Hawley, Tom Cotton to start lashing out on social media, because how do you do that when like it's so narrow, so methodical? And so I do think that the judges, by and large, see what they're up against, and with the exception of like the birthright citizenship order, which luckily thus far we're unanimous across the board, right, in keeping all of that on hold nationwide. The judges are realizing that like they are operating in a moment where they need to be prepared for the administration at any moment to go to the Supreme Court and say, fix this.
Okay, I lied. I had one more question to ask you, and because this one's about Social Security, and I'm very concerned.
Yeah.
They keep saying they're not going to touch Social Security. They have fired people at like, I think 10 different Social Security Administration offices, and you just wrote a piece yesterday.
Yeah, I think you published before midnight.
The entire Office of Civil Rights and Equal Opportunity at Social Security Administration was eliminated. First off, like, I know these guys were obviously a lot of DEI and whatever. No, what does the Office of Civil Rights and Equal Opportunity at Social Security Administration do? And by how many decades did it even predate the concept of DEI?
Yeah, it is the office where responsible for discrimination complaints, for harassment complaints, for accommodations, disability-related accommodations. This is like the internal office that across the nation deals with that, deals with all of those basic protections of the employees across the Social Security Administration. This wasn't brown bag lunches. This wasn't like this was very real harm happening to employees, and this was the office in charge of protecting it. The one thing that I talk about in my article was an employee who, as of Monday, had been a director at that within the office, basically saying that the office had been eliminated, and please wait for instructions from the agency to request EEO counseling, which is how you start a discrimination complaint, report harassment, or guidance for reasonable accommodations. In other
words, if I'm working at a Social Security Administration office in in central Massachusetts, and the ramp into the office broke, and my boss there says, "Nah, I'm not going to replace that. We don't need to do that anymore. You got to figure out a way of getting up those stairs." This is the office that I would contact. Yeah. As an employee and say, hey, I can't get into my office. Like I have to go around and I can't get into my office now. And this is the office that would deal with that complaint. Or if I've got a boss who's going, hey, sweet legs, and I go, hey, you're not supposed to be doing that. And this is the office.
that's the office, and the Baltimore Banner got somebody from the Social Security Administration, a spokesperson, to acknowledge that it was 140 employees who were placed on administrative leave immediately within that office. One of the questions that I raised is that the office had several centers within it that it was responsible for. It's not clear if they were a part of these administrative leave. And the problem is that while the acting administrator, the acting commissioner of the Social Security Administration, who himself took office after all sorts of DOGE-related confusion last weekend, if you didn't remember, the Washington Post reported on this, and Marissa Kabas at the Handbasket has also done some follow-up on it, where this guy Leland Dudek, who's now running the administration, he says that they're going to be moving around the statutory responsibilities, which I thought it was interesting. He admitted there are legal responsibilities that were the job of this office, and everybody who was responsible for carrying out those legal obligations was placed on administrative leave yesterday. And while Dudek says that they're going to reallocate responsibilities, he didn't say where they're going. And so, yeah, if something happens this morning to you, it's not clear that the Social Security Administration has anything in place to actually deal with that.
Is he allowed to do that? I mean, how statutorily, like when we have a statute, presumably passed by Congress, that's the way that it's been working in this country for really several hundred years in terms of like statutes. When the statute is passed and says, hey, there needs to be a division in Social Security that addresses discriminatory actions and whatnot, like, does he have the ability to sort of change that?
What could happen is that he could issue a memo saying that all of the statutory, it could be a one sentence memo, all of the statutory obligations of the Office of Civil Rights and Equal Opportunity will forthwith be the responsibility of the Office of Communications.
Okay, I see.
And he could do that.
But for as long as there is no assignment for those, the statute is not being followed.
I would argue that an agency employee would have standing to bring a lawsuit saying that the agency is not
fulfilling
its statutory obligations.
Chris Geidner, proprietor of the Law Dork newsletter on Substack. Really appreciate your time today. There's so much going on, and it's really important that people have at least a clear perspective on at least the broad categories of what's happening, and you really helped us with that today. Thanks so much. And we'll, of course, put a link to the Law Dork newsletter on Substack.
Thanks.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.